I think that there is a misnomer in the community that you have to be wealthy to need estate planning, such as a will, power of attorney, healthcare proxy, or other legal documents in this regard. Every adult person should have estate planning in place. Of course, the extent of the estate planning, the documents that an individual may have, will vary based upon their needs and their wealth. But it doesn't mean that if a person has a modest income or modest assets, that they don't need to provide for what they want to happen to those assets someday when they're no longer here. Most of the time, when people come into the office to discuss estate planning, they're thinking about documents that will be relevant once they die. But I explained to them that there are certain estate planning documents that are very important for situations where they may become unable to take care of their affairs, but they are alive. And these are what I refer to as the lifetime estate planning documents, such as powers of attorney, healthcare proxies, and living wills. Beyond that, we do get into documents as part of the estate plan, which are going to be important once they pass away. And these are things such as last wills and testaments and various kinds of trusts. A will is one component of an estate plan. The will is going to be a document that expresses, number one, who your executor should be when you die. This is your fiduciary, the person who you choose to carry out your wishes once you're no longer here. The will also gives you an opportunity to state how you want your assets distributed once you die. But a will has to go through the probate process. People oftentimes come in and say, oh, wait a minute, I thought if I had a will, I would avoid probate. And that is not accurate. Any assets that an individual has which are not containing a designated beneficiary or are not in joint name with another person, assets that are solely in the name of the deceased when the person passes away, will have to go through the probate process of the will. This is where the surrogates court gets involved and a probate proceeding has to be brought. We oftentimes speak about how do we avoid the possibility of probate. And here we speak about utilizing various types of trusts into which we can title assets so that when our client passes away, the designated trustee, who is the fiduciary in a trust, will have the legal ability and the legal authority to carry out the wishes in the trust without having to involve the court system. No matter how old you are, if you or any of your friends or family members are in need of estate planning, please reach out to us at Angiuli Gentile. We're here to help you.